Yes. Hence, this appeal, FMA 262 of 2026, stands disposed by modifying the judgment and award dated 11/7/2025, passed by learned Additional District Judge, 5th Fast Track Court Alipur in MSC case number 31 of 2016, to the extent that the claimant respondent will be entitled to rupees 10 lakh along with interest at the rate of 6% per annum from the date of filing of the claim case till realization, excluding the COVID-19 pandemic period from March 20 to December 2021. The appellant National Insurance Company Limited shall deposit rupees 10 lakh along with interest at the rate of 6% per annum before Register General High Court Calcutta within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is already deposited, no further deposit be made. The respondent claimant will be entitled to withdraw rupees 10 lakh along with interest at the rate of 6% per annum as observed above. Balance amount, if any, with accrued interest be returned to the appellant National Insurance Company Limited. The appeal FMA 554 of 2023 stands dismissed. The judgment and award dated 29/4/2023, passed by learned Additional District Judge, Fast Track 5th Court Alipur, House 24 Parganas in MSC 34 of 2016 is affirmed. The appellant shall deposit the compensation awarded by learned trial judge along with interest within 8 weeks from before Register General High Court Calcutta. In the event it is not deposited, the claimant respondents will be entitled to withdraw the compensation upon compliance of necessary formalities. Yes. For the
Content matter.
matters.
Content matter item number 10.
In that request last episode was allow some time to filing contracts. That's now it's handing over the report. Kindly give some time so that I can get back with the report.
Just not today then. Acha, learned advocates for the parties are present. Let the affidavit of compliance filed by the contender respondent be kept with the record. Let it appear on 17/7/2026 for orders.
Online.
Huh?
Eleven met. Same order maybe.
Same order as in 10.
11, 12, 12, sir.
12, 12. Yes, 11 and 12 same order.
No, well, 11 maybe.
11 same order.
10, 11 same order. And 12?
12 same order.
Okay, 12 also same order.
Starting maybe.
Same order. Okay, same order.
What in?
14 melodies matter has come before you worship for the first time.
So service is not so service be done.
Yes, madam.
Yes, learned advocate for the petitioner is present. A record to the
Dated madam 3rd October 20. Page 17 of my content.
This application is directed against violation of order dated 3/10/2025 passed in WPA 2074 of 2025. Let notice be issued upon the contender respondent and affidavit of service be filed. Let this matter appear on 24/7/2026.
What is written?
You have got contaminated respondent. What is your instruction? Copy is served upon you. So what is your instruction? So I keep it after 2 weeks? Yes.
What appears technically, yes, there is a delay appears from the records. But he had also taken instructions from the PS and everything which might take it
Okay,
anyway.
so I'm keeping it after 2 weeks. Learned MS Alam appears for the container respondents. As learned counsel is appearing for the first time, an opportunity is granted to take necessary instructions in this matter. Let this matter appear on 24/7/2026. Twenty 24/7.
Item number 3.
Yes.
The matter was the revision application lordship was admitted by your lordship through an order dated 18th of October.
You are for the state. Why, who is appearing for the state?
Lordship, this is a complaint case for so state.
Okay, so state is
Does
not.
not appear in this matter.
It's a complaint case.
First 163, thereafter 200 CRP. Your lordship order.
Okay, what is your prayer in this application?
Lordship, prayer is for quashing of the proceeding, but thereafter your lordship granted me liberty to take adjournment before the learned trial court, as because the matter is subjudiced before the honorable
Which section the case is instituted?
case is instituted under firstly lordship, the case was instituted as 156(3). Thereafter it was converted into a 200 CRPC application as because there was no communicable offense found out. 500, 504, 526, 34 and IPC law. And lordship, what was I was paying the CRAN
So
one.
what is the ground for quashing?
Ground for quashing is lordship. Firstly, lordship, this case was instituted as a 156(3) application before the London magistrate. Your lordship also know that for filing a 156(3) application, an affidavit of the complainant should be annexed with the petition. That was not there. No affidavit was filed, and as per the judgment of Honorable Supreme Court in Priyanka Srivastava, thereafter lordship.
Let him complete.
No pleading
Yes.
is made.
Let us see. It's a question of law quashing.
They
Let us
have
see.
made
Thereafter, kindly.
So what is the nature of dispute between the parties?
They have been defending me and my junior, the worship, and have been implicated in number of false cases. I have submitted
The counter was actually lordship.
there is no, and all the complaints they have made has been stated by.
Defamation case is not made out as because of filing complaint with the police authorities. Defamation case has been made out.
Let me see your grounds of quashing.
Last order
Yes, Lord.
11/9/2026, state was not
So the
granted.
cases are for defamation. Under which section?
504, 506, 34.
And it has been made out, the, whatever pleadings they, whatever submission they have made is not in the pleadings, your worship. Only one line.
Question is, see, the matter can be decided. But was this matter earlier sent to mediation?
No,
No,
it has been decided.
The problem is lordship.
No. See,
No, it was not sent for mediation.
so the question is, now the question is,
It has become
yes, let me see.
It cannot be lordship. Yes.
Hey, yet any,
Worship, I have made.
let me see this order.
applications.
Without serving me notice, I was not there, lordship. It was an order for expedition. And this is the last paragraph.
And I have already filed.
No, this application.
Yes.
This application, that
filed.
was in absence of myself, that was decided.
We should have made prayer after an application grant.
And lordship, that initial application is also in progress. I will submit subject to permission.
last year, so there was
Anyway,
no.
you are-
Lordship, she was aware about the quasi proceedings because she was appearing priorly. Thereafter, she filed expeditious disposal because this court, CRAN 2 hearing. Thereafter, in presence of CRAN 2 is pending, she has filed another application for expeditious disposal before the learned coordinate bench without informing this thing.
But all the orders.
And another thing, Lordship, I shall submit before submit your
How many
Lordship.
petitioners are there in this case? Two.
Myself and my junior.
No, this case.
Yes.
4570.
Two petitions.
One is Sanjukta Samant.
And this Robin Datta, I am appearing.
You are for?
Robin Datta, second petition.
And petition number one.
Petition number 1 does not represent Lordship. I represent the case.
So how can you anyway?
On
You
strength
can
of
represent
POA.
for yourself.
Yes, Lordship. I am appearing for myself on strength of POA.
So Sanjukta Samant is advocate.
She is also advocate. I am also advocate. Lordship.
The lordship. she is
Lordship, you are
present-
And the opposite party is opposite party number two.
Presently, she is.
She is Malavika Saha. Another is Sormishta Paul.
Yes.
She also does not appear.
So they are also your
Two,
learning is
yes.
appearing in person.
Your Lordship granted adjournment, granted liberty to take adjournment. Learned trial court rejected that adjournment prayer. That's why, Lordship, I have come up before your Lordship.
What is the ground for what ground it has to be quashed?
Yes, Lordship. Lordship, kindly see the certified copy of the original complaint. Can you see?
Resulting conflicting orders, so lordship. this
No,
is-
no, I am going through this petition. Whether if there is any ground to quash, then it can be considered.
Lordship,
Another thing, I am
11-9 order dated 11-9-2025, where the honorable court, having determination, had said that we do not find any that the proceeding will be stayed.
Lordship,
Then
that was
the
not there.
order, then the opinion was of the honorable court that the stay application may be heard on 6th of November by Honorable Justice Vikas Chandra, but Honorable Justice Vikas Chandra declared on 4th November. Thereafter, for 4 months, they did not take any.
so
step.
thereafter the matter was released and assigned.
No.
This is an assigned matter.
Justice Honorable Mikhail Chatterjee never takes their matter.
No, question is,
That's
this
why
is, that so the matter was released by the regular bench.
by Honorable Justice Mikhail.
Yes, that is what I am asking, by the regular bench.
Never takes their matter, your lordship.
That maybe, but
Yes.
whatever it is, after releasing by the regular bench, the
Yes.
matter is assigned to this bench.
Yes, and they always try to avoid
Lordship,
the.
kindly see the original complaint that was filed by them before the learned trial.
Yes,
Certified
which page?
Lordship, I am referring to the certified, the original certified because it is misread. Otherwise,
Yes, that is.
original CR.
Page.
It is attached to the original CR. Pagination is not there with original certificate.
Yes. Xerox is also there.
After 109 is the last page there. Lordship, the order is that first order dated 28/12/2023. Lordship has got first order.
12/2023.
Yes, Lordship. The order is this is an application under section 156(3) CRPC filed by the petitioner, praying for a direction upon the OC Hardship PS for causing investigation into the matter by treating the same as FIR under provisions of 156(3) CRPC. That is the relevant portion of the order. Why I am referring, I will come later, Lordship. Thereafter, next page, Lordship. The orders are continuing. Thereafter, after some pages, the original complaint they have filed. That is there. The original petition before the learned Chief Metropolitan Magistrate.
Page, okay, next page. Okay, this is the
The petition.
examination.
The original complaint. Lordship.
Yes, examination under section 2.
Examination of the witness.
Yes, Lordship. The two examinations are there where she is stating that kindly see the examination of Sormishta Paul. She is stating the complainant is of this case is my senior in practice. At present, I am practicing before the Honorable High Court, Calcutta. Means Sormishta Paul is saying she is not the complainant. Complainant is Malavika Saha, who is a senior.
The complaint itself reveals that we both had submitted complaint after they had harassed us.
Lordship, may I be permitted to submit because she is interrupting, Lordship. Kindly.
Anyway, you submit.
Yes. Kindly see the deposition of Sormishta Paul. Your Lordship has got that.
Yes, I'm just going through this.
Yes, since the time we have been appearing on behalf of our client, Dr. Deepak Sangara, the accused obtained our details from the Okalata. This is allegation. Accused number one sent derivative emails to my senior. My name was also mentioned in those emails defending our client. Since we appeared for our client in the district court, both the accused started abusing us in filthy language in person, and this continued for some time. When our client was enlarged on bail by Honorable High Court, the accused started harassing us more. Later, we filed lead petition against them due to our unparliamentary behavior. The accused person also often threatened me when I remained in the High Court corridor to withdraw ourselves from the case pertaining to our client. Both accused followed me in different courts during the district court or Howrah, the city sessions court at Bansal, and the Honorable High Court at Calcutta as to ascertain and in which courts we are defending our client, Dr. Deepak Sangara. I am the advocate on record of those cases where the accused have filed complaint against the Honorable Justice of the Calcutta High Court. No proof, Lordship. She has threatened me and my family with dire consequences if I don't withdraw from the case pertaining to our client. She is the witness. Kindly see them come to the complainant. According to them, Malavika Sai is the complainant. Next page, Lordship. I have filed the present complaint against Samyukta Samant and Ramit Datta. I am a practicing advocate at Honorable High Court at Calcutta with registration number this. I was defending my client Dr. Deepak Sangara when I came to know from one of the emails of accused number one, Samyukta Samant, that she has come to know about my personal details, official designation of my husband, namely Kono Shah. I will say just one line about this ground because prior institution of this complaint, this Kono Shah, her husband, and Deepak Shankar Rai had committed sexual violence and sexual assault within the lawyer's chamber of Samyukta Samant.
Let us see.
Yes, sir. Thereafter, she also sent defamatory emails to the different police authorities in West Bengal. That is the allegation of defamation. And Hello, using an email ID. She also mentioned in the emails that she has filed criminal complaint against me and my husband for reasons best known to her because I had not met her till date of receiving the emails. Great, Lordship. Upon receiving the emails, first I went to the Bar Council West Bengal for registering my complaint against accused number one. Later, I submitted formal written complaint against her to the Bar Council. I also went to the Damdam place and filed the written complaint. When I appeared on behalf of my client and prayed for his bail, then the accused number one had been filing endless number of cases against me. She also sent derogatory emails against my husband. Accused number two, being the husband of accused number one, had also filed complaint against me, representing herself as an advocate, whereas he is not really one as per my knowledge. No documents and nothing is there, Lordship. The accused number one has also threatened my clerk and abused him in filthy language. The call records have been submitted to the police authorities. He has also filed a complaint against Honorable Justice to Honorable High Court for Justice. But it's total contradictory. Thereafter, Lordship, it is coming the complaint. Kindly see the sign by Sodhi.
One by one, please.
First page of the complaint, Lordship, before the learned chief metropolitan magistrate and application under 156(3). To file an application under 156(3), the mandatory provisions are there. You have to comply with the provisions of 154(1) and 154(3), and that should be expressly mentioned within the application made before the magistrate as per the judgment of Honorable Supreme Court in Priyanka Chilotra. If your Lordship says, I can produce the judgment.
You punish, you argue, and thereafter you punish.
Yes, Lordship. Kindly see the petition and sign of the advocate filed by Shormishta for advocate. It is signed there at the upper part corner. Right hand side, upper part corner. Shormishta for. In every page, if your Lordship will find the sign of Shormishta for advocate is there. Means she is filing the complaint on capacity of an advocate. Thereafter, Lordship, kindly come to the affidavit page. I don't know, this pagination is not there within the original complaint. Kindly, Lordship, see the affidavit page first. Yes, sir. Kindly see the affidavit page.
Affidavits.
Exact last page of the complaint. It is not paginated, that's why, Lordship.
Anyway, Paragraph, yes, not paragraph.
Verification and affidavit page. Your lordship has got exact last page of my
Yes.
petition. Kindly see the affidavit. I, Mr. Paul, cease doing oath before the notary public. What she is telling? Paragraph number 1 within affidavit. I am the petitioner of this case. I am well conversant with the above noted facts. That the submissions made above are true to my knowledge and belief. Statements above made are true to my knowledge and belief. Repeated. And also see the sign, deponent Mr. Paul, prepared in my office, Mr. Paul advocate. Where is the affidavit of Malavika Shah if she is the original complainant of the case? Because the application was first treated as 156.3. It was not first treated as 200 CRPC. At the very instance, during entertainment of the petition, it was ought to be rejected in the light of the judgment of Honorable Supreme. The mandatory guidelines. So Mr. Paul is not saying also that I am the petitioner number this, I am affirming this petition on behalf of this. This is the technical ground, Lordship. As
That
per
is clear. Case is only under defamation.
Your lordship, whatever he pleaded before your lordship is not mentioned anywhere in the application.
Now,
Criminal
question
application
is
not
your case is under what? Only defamation or other
intimidation and defamation.
that is 506. 506
504, 506 and 34.
and 35. 506, 504 and 34.
504, Lordship. 506, both.
500, 504, 506.
506, 504 and 34 IBC.
And 500. Defamation.
Yes.
And your lordship,
These are the sections which are given by you.
Incorporated and landed by
Alleged by you. Okay. How many cases are filed by you against her?
Lordship, not on my personal capacity. One complaint is pending before the landed Howrah court.
No, by in your personal capacity. How many cases you have filed in? Yes.
In my personal capacity, one case,
One.
one complaint case pending before landed
Under
Howrah.
what section?
506 30. The case number is complaint case 334 of 2023.
to date, your lordship, they have not served the copy.
Anyway, that case you are appearing.
They have not served some.
That is what. That is 200.
That is 200 CRP direct complaint filed before the magistrate.
That is under same. That is 506 and 504.
No, 506 and 34. Two sections only.
506 and 34.
34.
Only against her or another person.
Only against her.
Okay. And which was instituted first? Your case or her case? So your case definitely.
2023 lordship. Lordship, as your lordship has asked for
12, 15 cases, your lordship.
lordship, as your lordship.
As date, they have.
No, lordship.
Now the question is to see.
I am telling lordship.
Now another thing is definitely I'll hear both of you and take a decision. But you see, instead of dragging this matter, you see how the cases which you have filed and what the cases which he has filed, these are all compoundable offences.
Yes, lordship.
So if you both of you decide, I can send the matter to mediation to resolve the matter, okay, instead of dragging it.
Your lordship, I may be allowed to submit.
Lordship, the proposal granted.
For 5 times.
How many? How many cases?
Five.
If that falls submitted, this honorable High Court has declined to cause the petition. These are involved there.
They have five, 370.
That is why you see, if the matter is sent for mediation,
No, not only your lordship, for my husband. They had filed against.
They have been charge sheeted. PID file charge sheeted.
They have, which has.
Exact false
which has-
statement of answer.
False. All are kept in this.
all are resulted in FRT.
No lordship.
False cases.
Now,
Lordship fine.
now at this stage, now you see,
Now the lordship. Cases are being with.
Kindly take the order by honorable Supreme Court.
CID has investigated this matters, and whenever these matters came before Honorable Justice Tiktok Ghosh or any other bench, when the court found their guilt, they immediately filed complaints against the sitting judges, honorable sitting judges, and this has been their practices, your lordship. I have all the evidences which shows they have been evading proceedings just because I will be able to prove how they have filed all false cases before different courts.
and I have to grant both of you, see, after hearing both of you,
Yes.
if you want me to go through all this,
Yes,
I have to grant both of you to file written notes of arguments along with all documents.
yes, your lordship, by that time, evidence may be, I
No,
will adduce evidence because it is.
No, if I have to decide the matter, how can I allow the trial court proceedings to continue?
Lordship,
If I have to decide the matter,
Your lordship, Lordship, your lordship granted liberty to take adjournment.
Another thing, you see, if both of you decide, the matter can be sent to mediation. So all the cases.
She is not agreeing with it. I am saying the matter has come up before honorable justice belongs to Batra. They have asked honorable advocate Shekhar Bose as a mediator. She was not agreeing with it. So lordship, this is not my
Now,
part.
what is your desire?
My husband is selected by the UPSC. He is a gazetted A-class officer as a defense personnel. He called his wife when his friend was missing. My father-in-law's friend had called from Vellore that my son is missing. They had gone with them. So please make a call to her. Just for one call, where he is now, they have implicated him in several criminal cases. Charge sheeted.
Lordship, she is saying this.
Police has been
Police filed charge sheet. CID filed charge sheet. Her husband is under trial at least. He has to file.
The question is, see,
He has to put a document.
in
Only
one-
one should be the chief.
in one case you are
Your Lordship, my husband cannot be honorably discharged if because they have alleged that I have been always requesting, I have been pressurizing them to withdraw the cases.
question is, you see,
My
if
She is ready to. She is not ready for BTS. That's what she
question is,
Kindly
if
decide.
the matter is dissolved, under 482, all cases can be quashed.
Your Lordship, my client who is the
He wants to defend her client, Lordship, not
My
herself. She is
son-
bothered about her client.
Everybody is there
And
implicated.
he has also implicated me, Lordship. Can you see the Supreme Court order? I had went before Supreme Court for quality of the FIR
I
is being.
have evidences of defamation, Your Lordship. They cannot go on defaming people and implicating people and let.
Lordship, defamation has to be done before the third party. I am filing complaint before the police. She is telling I am doing defamation.
It will not.
She has given evidence before the learned trial, but your Lordship also observed so.
These sections are very shameful.
And Lordship, yes.
And what they did.
Huh?
So are you ready and willing to withdraw all your allegations?
Let them withdraw, Your Lordship.
No, then only I can, if it should be from both sides, from your side as well as from her side.
Lordship, only the person of case, she cannot ask this court to withdraw the case against the client.
If you withdraw the allegations and complaints made against her as well as her husband,
Yes.
then I can also insist that you also withdraw all the cases. It has to be two-way.
Yes, Lordship, if your
Now,
Lordship says so.
If both of you agree, I shall record that both of you are willing to withdraw the complaints and allegations made against each other. That is why I am sending the matter to mediation. Okay, any retired High Court judge or whatever it is.
Whatever.
And I shall fix the matter after 4 weeks.
Your Lordship.
Grateful, Lordship. If your Lordship says so, I am agreeing with you, Lord.
Bar Council of India has already decided my matter.
No order, sir. Kindly ask her to show the order. Kindly ask her. She is only making false orders.
His wife is under suspension presently.
No, Lord. Kindly ask her to give the order.
Your Lordship.
This is the Bar Association and the petition is pending for Justice Pignala.
And Bar Council will also pass. This is a very serious matter. Your Lordship.
How she can apprehend about Bar Council of India?
You see,
Abduction and abduction. They have abducted.
that is what
Lordship,
he has
that is the counterblast of the Supreme Court.
that is why he has to, you see,
I can.
he has to withdraw the cases and allegations, okay, made against each other, okay, as well as you have to withdraw the allegations made against him, including this case.
Only this one I can.
No, whatever complaints and allegations you have made, all both parties are ready and willing to hold talks for settlement and to withdraw cases leveled against each other. That is why I am sending the matter to mediation. Let the mediator, because let there be a peaceful settlement. You see, otherwise, whatever order is passed here or by before the trial court, the matter will not end. It will go higher up.
Yes, it has gone up.
Yes, that is why.
They are under anticipatory bail. They are not taking.
Now that is why.
And I cannot see.
That is why you see, both of you can resolve these disputes peacefully by intervention of a third party, that is the retired High Court judge, so that after 4 weeks you come with a solution. Okay, if the matter is resolved, no more question of any fight and contest, no more tension, everything will be resolved.
Your Lordship, I can do my part. But if it comes in the way of, because vigilance clearance has been denied to my husband, who was to be promoted as additional Director General, Your Lordship.
You see, After these matters, you see, after these matters are settled, both of you will withdraw from the case, and if it is not withdrawn, the High Court is empowered under Section 480 to quash all the cases. That power the High Court has probably provided. Both of you have settled all the cases. So it's a matter can be settled. It's not a very difficult task.
I have only one case. They have.
Not one case, he has complained to the bar council. That is out there. He is not telling us this.
Only the effective case, because their false cases are stayed. Now they are facing the evidence.
You see,
Now they are
unless you see, it cannot be a one way. It has to be both way.
to do your lordship, but they must
Good.
themselves.
So I'm sending the
Not about faster.
I'm sending the matter to mediation. I'm keeping it after 4 weeks or 5 weeks. In the meantime, you see, sit before the mediator, see what solutions can be arrived at. If the matter is resolved, a report will come from the mediator. On the basis of the mediator, I can pass necessary orders. Because on the basis of the mediator, so this is settlement. Both of you will have the obligation to withdraw the cases. If on the basis of the report it is not withdrawn, definitely that is a plea to be taken before the court. That the matter is settled and he has taken the plea.
That will be ground for question.
Yes, that will be ground for
Sir,
question.
and the doctor, an oncologist,
See that.
let me finish. He is not willing to withdraw his FIR, whom I am representing right now. I can withdraw my case if they undertake not to implicate people in future.
No, why is it
All
undertake?
this is your
If civil commit committee of the thought case,
Because
Lordship,
they
You see,
she is not wanting to mediate.
whatever.
your lordship.
You see, if the mediator thinks fit, he can call the third party.
Yes,
That
your
power the
lordship.
mediator has. Anyway, I'm keeping it after 4 weeks. Here, take those learned advocates for the parties are present.
Lordship in person.
Oh, sorry. Learned advocates who are pleading their cases in person are present. Heard both the petitioners and the opposite parties, who are the learned advocates of this court. It is the contentions of the parties that they have instituted cases against one another. Stop. Upon hearing the parties and considering their nature of profession, this court is of the view that the parties will act reasonably to resolve their disputes. As there is a chance of settlement, the matter is referred to mediation. Dash is appointed as Dash is appointed as the learned mediator. The Honorable Justice Subroto Talukdar is appointed as the learned mediator of this case. Learned mediator is requested to make endeavor so that the dispute between the parties are resolved. The parties are requested to appear before the learned mediator on the dates fixed by him. Let this matter appear on 21/8/2026 for report of the learned mediator. It is expected that as the matter is sent to mediation, the parties who are learned advocates will not take any steps before the courts. Fixed 21/8/2026 for report of the mediator and further orders. Let a copy of this order be sent to Secretary High Court Mediation Committee for necessary steps. It is already
Lordship, Monday is the date before the trial.
Department is directed to send a copy of this order to the Secretary High Court Mediation Committee.
Lordship, Monday is the date fixed for trial.
I have recorded that it is expected parties will not take any steps before the court. Yes, 21/8. You see that the matter is resolved.
Started by them, let them understand that harassment should come to an end.
Coming to item number 44.
Appealing on behalf of the applicant. I am led by Advocate Dhananjay Gandhi in this matter.
What is this application, Ganwar?
I have got instruction from my senior, Your Lordship.
Okay, not today then.
No, Your Lordship, there is a request from my senior.
Yes.
Kindly, this matter was already fixed on 27/4/2026. It was already heard on the last time, but Your
No,
Lordship.
matter was fixed when?
On 27/4/2026.
Matter was heard.
Yes, heard in a possible period of time, but.
Show that order. Taking order,
It's 20, and last order was 2020.
কত ছিল
ethics হওয়ার কথা ছিল।
একটু সময় ছিল কোনো কারণে হয়তো আপনি মশক
You are appealing for?
The respondent, my lord, I am.
Record an order. Learned advocates for the parties are present. As this matter was fixed earlier, let this matter appear on 1/8/2026.
Any content?
Yes, 1/8/2026, that is the working Saturday.
45 and 46.
Respondent.
45.
45 and 46.
Yes, what is this? Whose application is this?
Application on behalf application filed by the petitioner. Your Lordship.
Appellant.
Yes, appellant and for the substitution.
By the petitioner appellant.
Yes.
Okay, not today.
47. 48. 48.
48, yes.
Not today.
Yes, 48. এটা কোনটা রাখছেন অ্যাপ্লিকেশন 2 এর হেডিংটা? Yes, 48. You are appealing for? 48.
Yes, yes.
What is your application for? Okay, not today.
49. 50. 51. Hey. Hey, now. 152.
51.
Not today করে দিস।
Okay, not today.
52.
Not today. 53?
না,
Oh, 52.
52.
তো এখানে হয়ে যাবে।
তাহলে মাঝে মাঝে আসবে।
is one allocation system in this petition that says below the case when it is below the
Yes, call the list.
Listed matter to be mentioned, item number 1,
Okay, not today. Yes, item 1. Yes, record and order. Terms of earlier direction dated November 28, 2025, directing the department to return the volume which was produced in court by the Register of Assurance. Necessary compliance is made. Let this matter appear on 17/7/2026. Yes, call the next.
item number 2,
And item 6, the item of my application was seeking preservation of certain CCTV footages when you are on
So
the
last week or last day, some directions were
Yes.
issued.
So we think. It's not big, and file the opposition. You are appealing the action.
What was the, let me see the order.
May I find a reply in this matter?
No, affidavit in opposition file.
That is in 2-1.
Yes,
But,
you are representing the opposite party.
Yes, sir.
You are opposing Mr. Ghosh's application.
Yes. Applicant in item number 6, I am the applicant in item number 2.
so item number 6, where I am the applicant, let me file my reply. She has filed an opposition, let me just file my reply.
Which matter is now taken up for hearing.
Now,
Item number 2,
Two, yes.
first is my application.
Okay, this is now taken up for hearing,
Yes.
consideration.
Yes.
So with regard to item number 6, there is no difficulty to file the affidavit in
reply
reply.
I am fine.
Okay, item number 6, that is GA 15 of 2026. Item number 6, GA 15 of 2026, ALA 115 of 1997. Learned advocates for the parties that present, let the affidavit in reply file. The affidavit be kept with the record. Let this. Yes, now with regard to your opposition to their, no, your application, Mr. Ghosh is opposing.
Yes, sir. That
So
is
he is to file the affidavit in opposition.
Yes, sir. Because I must indicate file an appeal in connection with the present proceedings in item. Not
Item number 2, an appeal is pending.
Yes,
Against which order?
not against last order.
Let me see. Last order means 19 June.
Well, it has protected them, I do not know.
Anyway, item number 2 against this, an appeal is pending. Okay, just a minute. Let this matter appear on 31/7/2026. That is item 6. That's item number 2. Learned advocates for the parties that present. The register original site has filed the report. Let the report file be kept with the record.
Maybe have liberty for a take.
Is just a minute. Liberty to, as the appeal is pending, the matter stands adjourned till 31/7/2026. You do it on the next day, okay?
And the extension to file the affidavit in opposition.
Okay, the time to file affidavit in opposition stands extended till 31/7/2000. No, opposition, no.
Opposition.
Stands extended till Okay, 31/7/2026.
These matters will come.
Yes, 31/7.
Well, in item number 6,
Yes.
Lordship will pass the order, that the interim order has been
Item number 6, the interim order stands extended till 7/8/2026 or till further orders, whichever is ordered. Yes, call for item number 3.
No, but only thing that what I find from the order, one, item 3, your lordship, might because that matter, but in the partition suit, your order 7, Rule 11 application has been filed, all parties have.
Item 3.
Yes,
This matter I am hearing this matter, item
this
3.
man, order 7, Rule 11.
Yes, yes, yes.
On the last day, on the last day, my lordship might recall Mr. Sarkar was addressing for some of the companies, and lordship order records the fact that today they should conclude, and on the next day, lordship has said, lordship will be giving the direction filing the notes. Today, lordship will fix it when parties will file, because for last 4.5 months, this matter has been heard, my lord. And only one, my lord, whether the company, my lord, can be brought into the hodgepodge of the partition. So that's what is that case. Now, my lord, what I find from the order, lordship possibly at 6 at 2 p.m. If that be so, I don't want to stand in the way. Kindly takes it up to
It is not indicated in the list.
but in the order itself, the order. So, well, I don't want to stand.
Let it be taken up at 2 p.m.
Yes, because lordship has said at 2 p.m.
Okay,
Mr.
2 p.m.
Sarkar may be thinking that it will be taken up.
Okay, okay.
What I want, let this be 2 p.m. lordship will take it up. I don't stand. Well, it will be
At least a date, next week, next Friday.
Only my lord is the order of the appeal court. I need to communicate it to the man.
Anyway, it's a part of the, all the matter parties are not here.
The order of the appeal court where my lord would recall my lord passed an order upon the plaintiff number 1 to approach the legal aid services to get an advocate appointed to represent her. So challenging that portion of the order, the plaintiff went to the appeal court. The honorable appeal court said, yes, well and fine, you won't go to, but you have to maintain a decorum. You can't go and abuse the judge or the learned advocate. The honorable appeal court has issued a clear stricture upon the first plaintiff, that if you do so, you will be held liable for contempt of court, or the my-lords can release the matter. This is the order because, and she has been given a caution not to behave in that fashion.
Now, what is left is your evidence.
Yes, my evidence.
I have kept it on seven. I can just one or what? Item number 1 ki ache order ke?
Well, in terms of the earlier action dated November 28th, the department that the volume which was produced in court by the register of assurance necessary.
The order of the appeal court file be kept with the record.
Once the next Friday, I am not there.
Week thereafter. 1 week, jury.
তাহলে ওটাকে ইয়ে করে দিন।
পুরো কেটে দেবো?
না, ডেটটা শুধু চেঞ্জ।
This is the matter I was arguing about the section 47 application. Execution of a consent decree.
Mr. Victor is not here. Now, one thing, subject to Mr. Victor's consent. You see, if both of you want me to decide the matter, I can decide here and decide. If both of you want me that you can resolve it because there is some chance of settlement, I can send it to me. Because you see, the matter will not end here.
Yes.
Whatever or decision is taken, it will go higher.
I have to take Mr.
So let Mr. Mishra come.
Yes, sir. He's on his way, man. In the meantime, London.
I can do one thing, I can keep it at 2 p.m.
Yes.
I can keep it at 2 p.m. Because you see, whatever is the decision, the matter will not end here. It will go on.
Yes. We'll talk and come back.
Yes, I'll take it up at 2 p.m.
The only thing 2 p.m. I have a fixed matter, item number 1.
Anyway, you
I
tell your
will
junior to
instruct-
be here.
Yes.
Take
Or
it
a slight passover, then 2 p.m. I will come and tell you.
because the court is right at 3:15.
Yes, yes. Before that, I will come.
For hearing item number 5.
Lordship, I'm for the plaintiff.
Lordship is again that matter, your Lordship,
But
because it has been disposed of.
No.
Your Lordship has come to a
I
finding.
have considered your submission.
No, Lordship. Lordship, on the last occasion, Lordship.
But there was a direction to file an affidavit, though I said, no, affidavit is not necessary, but they
What
were.
if I what? Reply?
Reply, Lordship.
Yes.
Lordship, kindly.
Record an order.
Kindly announce the week's accommodation.
Learned advocates for the parties at present.
But
Let
kindly
the
record only one thing. Affidavit is filed without prejudice to my rights.
yes. The affidavit in opposition filed to the application GA 31 of 2026 be kept with the record. The reply be filed on or before 23/7/2026. Let this matter appear on 24/7/2026. It is hereby made clear that the point of maintainability point is kept open.
Lordship, just another thing. Lordship. On the last occasion, for some reason, our appearance was not recorded.
Let the appearance of all the parties be recorded in the previous order.
100.
What's the appearance? What's the third? I think last matter.
Keep it at 2 p.m.
Yeah,
We'll come back on next Friday.
Can we come back on next Friday?
Friday. Just,
So just not today.
just
Acha.
parties will take it.
Item, this is
3.
item 3.
No, 4.
Item 4. I have to leave it in the report. Learned advocates for the parties are present. As there is chance of settlement, parties, learned advocates are requested to take necessary instructions as to whether they are ready and willing to go for mediation. Let this matter appear on 17/7/2026.
My interim order is also expiring on 17th March.
So we'll come back on that date.
The interim order, no, it is.
It is
Oh, it is there. Okay, that day I shall see.
next Friday.
So we'll come back.
appearance.
Number 7.
Your application for preliminary degree.
Yes, I requested you to give a list of dates and written notes.
Lordship, I'll take Lordship.
Yes, yes, just summarize the matter.
Lord, I need Lordship. I have corrected the chart also.
Yes,
Chart
yes, yes. That's why I requested you to revise.
Because the plaintiff, number 1 is the widow. Take better one.
Yes.
Of one Mr. Praveen Agarwal. The plaintiff number 2 is the daughter. Was a minor when Praveen Agarwal died. He was a businessman, a business Marwari man. The relationship of the parties will appear from a genealogical table which is page number 23 of the application. The Lordship takes page number 23 of the subject application, that is the genealogical table. So we'll take page 23. HON'BLE Agarwal, this is the dependent number 1. Manju Agarwal was his mother. That's a dependent number 3. Dependent number 3. That this first son is Naveen Agarwal. That's Praveen's brother. His wife is Shuman Gupta. Second son is Praveen Agarwal, who is died. And Payal Agarwal is the plaintiff number 1. Ishita Agarwal is the daughter of Praveen Agarwal. And the daughter of HON'BLE Agarwal and Manju Agarwal are Deepa Agarwal and Vinita Gupta. Are married to Vinit Gupta. Deepa Agarwal is the only person. Now kindly appreciate the situation.
from the side they are contested. The father-in-law, mother-in-law, brother-in-law, sister-in-law, the brother-in-law, they are not contested. The married daughter is coming in without
The joint family property.
It's a joint family property. Now, whether I seek with a preliminary decree in respect of what? In respect of those deeds, where will the name of
But
Praveen Agarwal?
this is what accounts.
Well, this is for there's an HUF of Praveen Agarwal itself I give up.
You
Well,
find
now
the list of dates also.
it's already in part of my. I try to keep it very short.
Yeah.
Now, whether if your lordship, the claim is for para to preliminary decree of the immutable property described in schedule, that's page number 203 to 204 of the application volume 2. As well as lordship will straight away come to annexure A here. Kindly take annexure A, for convenience I've given annexure.
Of volume 1.
Of written notes, kindly have a
Okay, written notes.
annexure A. That will be convenient. Page number 7.
Yes. Page 7.
Now the first property is premises number 23, Durgapur Lane, Kolkata 27. The said deed appears at page 121 of the application. Now the owners are plaintiff number 1, defendant number 1 and 3 and late Praveen Agarwal. So whatever Praveen Agarwal had, I am asking partition for only that. In addition to that, I am also the co-owner or the co-purchaser of the same property in question. So I do not want anything of HON'BLE Agarwal estate. I don't want for the time being. I don't want what I desire. And I say from Praveen Agarwal's estate, I am going to give his mother is entitled to that different number to 33.33%. That is, she is entitled to be lost, entitled to so we, whatever is in the estate of Mr. Praveen Agarwal, since this is
So dependent number 1, HON'BLE Agarwal.
I am not asking for any deed which is
that is movable properties of plaintiff and defendant.
Yes.
So you have confined yourself to the entitlement of the plaintiff.
Plaintiff, that is Praveen Agarwal.
Praveen Agarwal HUF shares.
That's all. And whatever is mine is mine. My name is so there is the deed is there, it's there.
That is your acquired property as well as share of the undivided property.
No, it's all are my acquired property. But it's standing in the joint name. I have purchased with my mother and my brother. This is always done with my funds. I want only my share. I don't want to say because acquiring will give me it's a joint family shares will go up because my daughter's share will also come in the grandpa. I don't want. I want to buy this. I'm a widow. I want share that is 66%, 66.66% in late Praveen Agarwal's property.
So Payal Agarwal is the plaintiff.
Payal Agarwal is the plaintiff. Number 1, Ishita Agarwal is the plaintiff. Ishita is the daughter.
Ishita is the daughter of
Praveen Agarwal. This is daughter. So daughter of this is Praveen Agarwal and Payal Agarwal's daughter is Ishita. Granddaughter of HON'BLE Agarwal and Manju. Very close-knit family If your lordship, this is my entitlement of the share, and lordship sees all the deeds records are in the name of the Praveen Agarwal or the mother of Praveen Agarwal and myself.
It was Vitakshara family.
Yes.
But so far the acquisition
is in my name.
Makes it in your name.
Conveyance, registered deed of conveyance with the presumption. For lordship's satisfaction.
That is the intention of the purchaser. If he wants the purchased property to go into that joint stock, then it is joint stock.
Yes, he was never that intention. Kindly have a look at it. Page 24.
So anyway, there is no contrary evidence to that.
No. Manju Agarwal, Praveen Agarwal.
Page 24
of the application. I just show because I do not want anything for it's a matter of trial on the estate of HON'BLE Agarwal. He is alive, whether I'll get it or not. Why should I get him all this one? Kindly have a look at it. Manju Agarwal, Praveen Agarwal, HUF. Page 20.
Yes.
Convinced you. So I'm entitled to the shares of Praveen Agarwal, HUF. Whose members I gave is Payal and Ishita. So she gets 33%, we get 66%.
Payal gets 33%.
Payal and Ishita gets 66%.
That is
One
33,
third,
33.
one third.
No, Payal and Ishita gets 33, 33.
33 and Manju gets 33. I am Millard. I said mother-in-law wanted her share. I am willing. She wrote a letter. I am
And that is 60, 33 and 33.
33. So 66%. Now Millard, one more deed I'll show. If your lordship kind.
What is the prayer in the plain?
Prayer in the plain is for partition of the property. Millard, if your lordship takes the
No,
plain,
declaration of shares.
para 33 of the application.
Para 33.
Para 33, page 12 of the application.
Yes.
Shares are admitted.
Plaintiffs are entitled to question for share in movable property.
Of Millard the estate. Millard, there are some deeds where Millard, both Millard, Payal Agarwal and Millard late Praveen Agarwal had purchased the property in both deeds. So Payal shares remains Payal shares. And Praveen shares remains, well, I get 66% with both of them. Both the plaintiffs get 66%. There are property Praveen purchased with his mother. So mother gets 33%, I get
The
less.
prayer was put for
Yes.
for the plaintiff.
Now, Millard, I had Millard broken it down in the manner as shown in Millard. Kindly take Millard in the manner that's also Millard part of my claim.
So your claim was this declaration.
Yes, Millard, what was I Millard take a Millard much lesser,
With
right?
regard to serial number 4.
Yes, absolutely. It was a higher prayer Millard for the interim preliminary degree. Millard, I am Millard coming down.
So with regard to actually, so far your claim is concerned, there was no written statement by either of the defendants.
But I am coming down. It will
So
be challenging.
thereafter you have filed this application.
Yes. And Millard, I want to come down. She's a widow. Millard, kindly use Millard prayer at page 19 of the application. Kindly help. Page 19. A preliminary decree for partition of the immovable property.
Page 9.
90, 1990. Immovable properties and annexure X to the application and shares of Mahalakshmi Vanijjo Private Limited, Piling Winters and Isco Steel Limited. Page 90, 1990. Now, Millard, Praveen had Millard shares on those in our own name, on his own name. I am entitled to Millard 66.66%. We both. That is my limited
So
prayer
these
here.
annexure X are also part of the scheduled property.
Yes, yes. Kindly have a look at annexure X. That is what Millard we made Millard in the notes as convenience. Kindly take Millard, page 8 is the movable property. Immovable lordship has seen.
Page 8. Yes, page 8. Movable properties.
Yes. Only Millard, I am restricting my rights, Millard, for the time being. If your lordship takes Millard on A and B, Praveen Agarwal and Praveen Agarwal H.
Yes.
So Agarwal HUF I will get or not get or entitlement Millard, that's a
Praveen Agarwal individual and Praveen Agarwal Hindu
HUF.
undivided.
That lordship will find serial number 1A, 1B, serial number Millard, serial number 3, 3A.
Yes.
That is all that. He has Millard, he has had shares, whatever share he had, Millard, he will get in these two companies. So far as Sabarmal Agarwal HUF concerned, be very fair to your lordship, Millard, in this preliminary degree cannot be granted. The lordship will kindly make a note of
So for this,
kindly Mahalakshmi Builders, Praveen Agarwal HUF, 68,000 shares, and Praveen Agarwal HUF,
Praveen
One-
Agarwal HUF is 1 lakh.
1,65,000.
65,000 shares,
Yes.
where the plaintiffs are claiming 100%.
Yes, because Millard, it's income tax assessed, the members are plaintiff numbers on it.
So that is why the plaintiffs are claiming 100%.
So far as Praveen Agarwal shares of 68,000 individual is concerned, 66%, because mother is getting Millard 33.40%.
Praveen Agarwal
6.60. That's 2/3. It should be 66.66. And that will be
Yes, that is 3A.
3A. And mother lordship say entitlement of the defendant number 3, Manju Agarwal, 33.40. Manju is the mother will get 1/3.
Yes, although it is not mentioned, it comes.
It comes, Milord, it will come. It is mentioned, entitlement.
Oh, right. The entitlement of defendant
I have personally checked up the chart this time.
Manju Agarwal, that is 8.33.
Yes, 8.33.
And
The Manju Agarwal is no, 33.40.
Manju Agarwal, yes, with regard to Praveen Agarwal's share.
Yes, Praveen, she is entitled to. In law, she is entitled. But how can I say she is not entitled? So far as Milord, they may say, Milord, I am not entitled to anything, Milord, but I have. Now, Milord, kindly take 3A filing builders. 1A and 1B. Milord, 3A, that's filing builders. Praveen Agarwal has 5,000 shares, which the plaintiffs are entitled to 66% and the defendant are entitled to 33%. Defendant number 3. Defendant number 3. That's 3A. I think, Milord, that's the best thing since they are not appearing, Milord. I now have a duty after this is, Milord, put on me to say, Milord, what is correct.
What is the position of law?
Absolutely. I cannot. Milord, 2 years ago, I would have pressed for it, but now, Milord, Lordship has seen me pushing too much in court 60, sitting with justice. I feel, Milord, but now, Milord,
Anyway, what is just and reasonable
this
for
is
an
the-
officer of the court?
absolutely. Now,
Yeah.
Milord, after this, Milord,
After that is what you
what
have
is
to submit.
comfort to me, Milord, it has some response. I
Yes.
cannot. And for the purpose of the note, if your lordship goes back to the note, judgment will be enough.
So what is your prayer?
And the
As per
annual return, if your lordship takes up, I must show the annual return of the first application.
Master summons to the
Page 69, if your lordship takes the annual return, what is there I have taken from it. What they have sold it for HON'BLE, Agarwal, it's a matter of trial. I cannot ask it.
No, because you see what you
Page
have
69.
what you have claimed in the claim
That
that
is for evidence. This
that
part is with
at this stage
can't be
so much at this stage
can't be done.
yes at this stage you want a judgment on admission to an admitted portion.
Admitted portion only.
Admitted portion you want a judgment on admission.
Absolutely.
Entire
You cannot
entire suit no evidence.
Yes. Relegated to trial if they come. If
Because you see, just mere admission does not mean that the matter is conclusively proved.
absolutely only my entitlement of my
So that is why, although there is no opposition to your this suit, you have come out with this application
on the admitted.
on the admitted portion.
Kindly have a look at page 81 of the application. This is from the annual return. Starts at 69. Volume 1 turning. Volume 1.
This is 81.
Page 81. This is part of the annual return. So the company has the annual return. Lordship will kindly
This is
have a
page 81 is Mahalakshmi Vanijya Private Limited.
file with the ROC, Register of Companies. We have to file it. Kindly have a look at this is part of the annual return. Page 80A.
80A.
Capital A. List of shareholders.
List of shareholders. Yes.
Yes.
It is attached.
Right box attached. This is the attachment. Milord Praveen Agarwal's share only I have asked for, and I have asked for share of Praveen Agarwal H. Serial number 1 and serial number 5. I have not asked for anything of Manju or Milord Naveen, and Payal share Milord remains with me. For that there is no partition.
That is why you have confined yourself
Only
to Praveen Agarwal and Praveen Agarwal HUF.
I am Payal. So Payal shares remain with me.
So Payal,
So Milord
Ishika and the other is this Manju have confined themselves to Praveen Agarwal individual, Praveen Agarwal HUF.
HUF Milord I would have, but Milord income tax it has been already assessed Milord that these are the
Plaintiffs.
So Milord, so far as Milord Praveen Agarwal HUF, Milord it will be 1/3 Milord to each. Plaintiff numbers 1 and 2 and defendant number 3. So far as Praveen Agarwal HUF serial number 5, 1,65,000 half. And Milord Payal Agarwal is me. That is Milord, it comes to 85,000. I remain the owner.
So 81 is the picture.
81 is the picture.
So for the movable properties are concerned.
This is Milord on the shares of this Milord company.
Shares of the company.
Now Milord kindly take the third one. By page 87 Lordship kindly have a look. The other one is not important, serial number 2. Will at page 87, Lordship, kindly have a look.
Yes.
Annual return of Miller, D. Miller, filing builders, that is the last annual return, Miller. Take page 87. Miller and the chart, Lordship will find. Miller, page 99, Miller, list of shareholders attached. Page 99. 87 it starts. Miller, 99, list of shareholders attached. Yes, fine. Miller, what is transferred is transferred. I cannot, Miller, help you. Page 100. I am not pressing it now, Miller. What is done is a matter of Miller trial, it's a matter of trial. I am not on that. Lordship will straight away come to 101. Praveen Agarwal had 5,000 shares. I am claiming a 2/3 rights in 5,000. And 1/3 goes to my mother. That's all. Well, they raise his joint family, they make an assertion, there is no contrary evidence. But for my lord's satisfaction, two authorities I rely upon. If it's a registered document, there's a presumption of validity. If your lordship kindly has 2009 5 SCC paragraph 5, I have indicated the page numbers.
Yes.
If your lordship kindly have a look at it. 2009 5 SCC 713. The bench was presided by Justice S.P. Sin. If your lordship kindly have a look at just below paragraph 22, that will support. The deed of sale being a registered one and apparently containing para 22, apparently containing stipulation of transfer right at interest by the vendor in favor of the vendor. The owners of whom was appointed dependent to show that the deed was in fact not executed or not otherwise reflect the true nature of transaction. Evidently, the avoid the confrontation with regard to the significant majesty witness of his father of the vendor who said sending the deed not executed. So whether it has a presumption attached to it, that logic will also find in paragraph 28. Paragraph 28.
Yes.
A document as well known must be constituted in entirety. Regarding the said document, there cannot be any doubts whatsoever that it was authentic and satisfied with the of section 54 of the transfer. But I think that is enough. 33. My junior wants to show me the para 33.
Yes, 33.
I think Miller that is enough. Also will have the same view of given in 2019 by Justice Anur. It has a presumption that if your lordship
So these are the relevant paragraphs.
If Miller para 36 Miller of that judgment, if your lordship kindly have a look at paragraph 36. 36 and 37. My junior wants to pay 731. If the appellant were to prove
Yes.
that the said deed was duly executed and it was neither a sham nor a represented transaction of different character, suit for recovery of position was matter. Heavy onus lay on the respondent to show the apparent state of affairs were not actually state of affairs. It was for the defendant in case of nature to defense. The first appellate court, therefore, in our opinion, misdirected itself in passing the judgment so far as taking into consideration the relevant facts and the decision based on wholly irrelevant conditions. A heavy burden of proof lay upon the defendant to show that the transaction was sham one. It is not a case where the parties did not intend to enter into transaction at all. Admittedly, a transaction has taken place. The only nature of transaction was in issue. A distinction must be borne in mind with regard to the nominal transaction, which is of no transaction, eye of law at all. The nature and character of transaction reflects a deed of conveyance. The construction of the deed clearly shows it was a sale deed. The stipulation with regard to the payment and compensation the appellant were disposed by way of such thing. In any event, any stipulation could be recognized. So even there is a stipulation. It could not be written. Here it's a conveyance consideration money. Praveen Agarwal paid Millard. Millard, it's a presumption, Millard. It's valid document. Same is the view. I don't want to multiply the authorities, Millard. It will have to be also.
Any other decision?
Yes. 19 to SCC in paragraph 5, it says itself, Millard, it's a recent view. I think Lordship can rely only on this. It refers to the earlier. Jamila Begum Millard versus Shami Muhammad. 19 to SCC 727, paragraph 16 and 20.
This is para 16 and 20. And this one is para 22.
Paragraph 22, 36,
26,
34, 37, 37,
34 and 37.
36 and 36.
Para 22,
36, 37.
36.
Will kindly have a look at para 16 of the judgment in question. A sale deed dated 21/12/1917 in favor of Jamila Begum is a registered document, and the registration of the sale deed reinforces the validity and execution of this. This is all I need to show. A registered document carries with it a presumption that it is validly executed. It is for the party challenging the genuineness of the transaction to show that the transaction is not valid in law. Here is not the case. Here it says, Millard, these are all joint family property. That's one line. No return, no HUF, nothing has been disclosed by them. Millard in Prem Singh versus Birbal, it was held as under. That's Millard 2005 judgment. There is a presumption that a registered document is validly executed. A registered document, therefore, prima facie would be valid in law. The onus of proof thus is on the person who needs evidence to rebut the presumption if the defendant has not been able to rebut the judgments are referred to in Vishwanathan such. So this is Millard. Paragraph 16 and 20 will reiterate the same. This is all. The second defense that would have been run but not run, but as a duty of para 11, Lordship comes to my note. Para 11. The defense of Benami could have been done, but that is now barred Millard under the Millard new Millard amendment of 2016. This is 2017 SCC 496.
It is
2017 SCC 496.
relevant paragraph.
Relevant paragraph, Lordship, you kindly have a look at paragraphs 11, 11.1 and 12. Your Lordship, kindly have a look at para 11, the last page. It is required to be noted that Benami transaction came to be amended in the year 2016. As per section 3 of the Benami Transaction Prohibition Act, there was a presumption that the Benami made in the nature of wife and children is for their benefit. Here, Millard, the deed is in the name of the wife. By the Benami Transaction Prohibition Act 2016, section 3(2) of the Benami Transaction Prohibition Act, the statutory presumption which is rebuttable has been omitted. It is the case on behalf of the respondent that in view of omission of the Benami, the plea of presumption that the purchase made in the name of the wife is for the benefit would not be available in the present case. The proposition cannot be accepted as held by the court in Benamani, while the Benami transaction would not be applicable respectively. Even otherwise, is observed of the plaintiff has miserable discharge his onus that the sale is executed where Benami transaction and the properties were purchased in the name of dependent upon Narayan Muralidhar from the amount received by him from the sale of their ancestral property. Once it is held that the sale in favor of the defendant were not Benami transaction, in that case, the suit properties except properties number 1 and 3 were purchased in her name, and the same can be said for self-acquired properties. and therefore cannot be said to be joint family properties. The plaintiff cannot be said to have any share in the properties except properties number 1. At this stage, it is required to be noted the learned counsel appealing to the number 1 has specifically admitted that the suit properties item 1 can be said to be ancestral property according to him. The High Court it is on the behalf of the defendant item number 2 and our ancestral property of the above the order of the High Court proceedings. If there's a sale deed, no evidence to the contrary, naturally that it is
So that transfer of property, that concept, to what extent it is applicable?
yes.
Transfer of property,
Yes.
that is ostensible.
Yes. Now, Millard, it's a property purchased by Payal Agarwal and Millard, Praveen Agarwal with Payal Agarwal.
So no
Praveen
contrary
Agarwal-
evidence to that.
Yes. Naveen Agarwal, Payal Agarwal, and the mother, Manju Agarwal. Naveen Agarwal and Praveen Agarwal, two brothers. Where is the concept? Father's name is not there in any of the property, except one. Where Millard, father, mother, and Millard, my Millard wife and Praveen Agarwal and his daughter, the plaintiff number 1 is there.
So this judgment answers to the proposition.
Yes. Where is the contrary evidence? And now, Millard, that presumption, it has to be for the benefit of the wife. I am the wife. Unfortunately, I am the widowed wife. And I am the minor daughter. So it's rather, Millard, in the final hearing, the shares will be more. Because presumption will be in my favor of all the HUF created by the grandfather. Because I am the minor. I am the widow. Not the other way around. So these are my respectful.
So page, that is para 11.
Yes. Para 11, Lordship, last page. Great. And Millard, summons have been served on all. None has appeared. That is Millard, the last annexure C to the note. Lordship, you kindly take annexure C to the note. That's recorded in the order. Page number 9. Order dated
Share C, page 9.
30th September 2024. Because they did not appear, substituted service made. The counsel for the plaintiff submitted.
Now, will you obtain a certificate that whether anybody has entered appearance or filed written
That's
statement or
Millard,
not?
that is Millard.
Yeah.
Service report is there, Millard.
No, certificate.
Certificate I have not, Millard.
The written statement or entering
They
appearance.
have not done so. Substituted service made, they have not appeared. If,
Substituted service made.
yes, yes. Kindly look at page 9. There was Millard, prayer for substituted service allowed.
Anyway, you have pleaded that in your petition. That's in spite of service none appeared.
Paragraph 11, Lordship, please. Page 11, I'm sorry, page 11. This is allowed.
And only the defendant who has contested is defendant number 5.
5.
Page 11.
Page 13, Lordship, kindly have a look at July 13 order
Page 13. In your notes.
in the notes. And the injunctions have also been confirmed, Millard. This is the preliminary decree, last chance Lordship gave
Page
this.
13. Yes.
These are the service order of substituted service. Receiver made inventory.
Pursuant to the interim order.
Yes. Kindly, Millard, have a look at it. I'm grateful to my learned junior Millard. Page 18, order of 27 November 2024.
Yes.
None appears, Mr. Such and such appears. None appears on different numbers 1 and 4. Counsel for the plaintiff submits, writ of summons do not be served. Accordingly, the plaintiff has taken appropriate steps to substitute service by way of publication. In spite of publication made by the none appears on behalf of different number. Of service is given. If counsel for different number 5 submits that he will not include the affidavit competition. And when Millard receiver was appointed, receiver was confirmed with the earlier.
And so far this application is concerned, the
Lordships,
defendant number 5 just filed written opposition,
Yes,
but they did not contest the case.
correct. And Lordship Miller's order records gave them last chance, not once but twice, and multiple occasions.
So they chose not to appear
To appear
and argue the matter.
argue.
Simplicity, they filed their opposition.
And opposition is nothing new. There is nothing. He says, I had Millard given a property in gift to my brother. How could I have gifted it when I have no money? How Millard, my father Millard, had entered some sort of negotiation with my father-in-law? Millard, no doubt.
Another thing, you have countered that in your reply.
Yes, absolutely. Rejoinder, surrejoinder. Then Millard, it says, Millard, you were living in the property, that is a joint family property. So he was the share. Look, she's an outsider. She's a married daughter. It could have been a scenario, son, daughter, Millard, it's a residential.
She has no scope to raise any objection so far the
In fact, Millard,
allocation of this person.
brothers of the offer of her brother. How can she have a right to the brother's estate?
The sole ground is the brother's property is the Benami property purchased by her money.
Kindly, Millard, have a look at Benami. What Benami means? Transaction means.
No, because do you have dealt in your written notes?
Yes.
The contentions made by the
Yes,
defendant number 5.
I have done it. Only Millard, the exception Benami now Millard, there's a new definition has come out. Immediate and future or direct benefit. Roman 3. Any person having individual being an individual name of his spouse or name of any child of such individual, and the consideration of property has been provided or paid out of the source of the individual. The individual is Praveen Agarwal. That is the exception, Millard, which has been carved out. Only wife and daughter or the children, rather.
I'm actually not habituated in seeing in this.
I give up. Kindly take Millard. 2, 9, Romans 1, 3.
Any person being an individual in the name of his spouse or in the name of any child of
Mother and daughter are the plaintiffs
the
here.
consideration for such property has been provided or paid out of the known source of the individual.
So whether anyone can benefit, it's me. Not Millard Deepa Gupta, my sister. The deceased sister, my sister. Even if it is held for Benami Millard, in his, I get the benefit. That is the exception carved out by way of the amendment. Lordship will pass an order for keeping. These are my list.
Learned advocate for the petitioner plaintiffs present. The Mr. Ghosh, learned counsel for the petitioner plaintiffs, concludes his submission in spite of granting opportunity to the defendant number 5. The none appeared on for defendant number 5 on the last occasion as well as today. Thus, hearing stands concluded. Let this matter appear for judgment on 31/7/2026.
Grateful for the inspection. I had reduced it, but I think that I.
Yes, maybe what is necessary for this purpose.
I should be. So it's beneficial under the new act. I'll get Millard almost 50%. I don't want.
Anyway, for the time being, you have to confine yourself to this.
Absolutely. I said Millard, in respect of the second company, Millard, I don't wait anything. It's a matter of trial. You already tried. Grateful.
Yes, all the next.
And Millard, this 2016 amendment, I give Lordship a copy. Ready? This is the vote. It doesn't have one. I am giving the vote. My Lord Court Officer a copy.
Okay, thank you.
This is an amendment. Should be 2016. Great. But no judgment should be necessary because the definition is itself.
Anyway, I have to consider the judgments also.
If necessary,
Because the judgments takes into consideration.
absolutely.
No, Justice Sinha's judgment is 2009.
9. That will on the sale deed. Presumption of validity.
Anyway, principles may apply.
Presumption. That's on sale deed.
Yes.
And 2020 judgment says Millard.
Take into consideration this amendment.
Amendment.
Anyway, both are applicable.
Absolutely. Great. Much.
Yes.
For final hearing, item number 8 and 9. Uddog Limited and another.
Item number 8 and 9. They appear for the plaintiff by learning that the application Mr. Bush was leading to have prayed for an accommodation. Is in some personal.
Okay, Mr. Ali is for the
Mr. Ali is also for the
plaintiff. You are for the plaintiff.
yes.
Okay, Mr. Bose is for the defendant. Yes, record an order. Learned advocate for the parties are present on the prayer of learned advocate for the defendant. Okay, for the plaintiff. The matter stands adjourned till 17/7/2026.
It should remain its.
Yes, yes, yes. It will retain its course. লেগেছে তো এস করে দেবে এস এস Yes, all the possible matters. 2 p.m. fixed matter.
2 p.m. fixed matter for hearing item number 3.
But on the last occasion, but I was not going through but just to not briefly capture it for 5 minutes. But I appear for different numbers 4, 5, 6, 10, 13, 24, 28, 30, 31, and 34. Now,
it is not your application, separate application.
I do not have a separate application. I have
Your opposition, you are dealing with this.
Yes, but I did. Yes, but in the affidavit in opposition that I have filed, but I have really not supported rejection of trade. Where I have not taken a stand, but similar to the sound.
Yes,
The applicant.
Your is on behalf of 4, 6, 10, 23, 24.
4, 5, 6, 10, 13, 24,
13 also.
13 also, yes. 4, 5, 6, 10, 13, 24, 28, 30.
Not 23.
Not 23, no. 24, 28, 30, 31, and 34.
Yes.
Now, on the last occasion, I have pointed out that there are 2 schedules annexed to the plate. One schedule talks about the shares of the companies of which I am representing, and of which they are seeking partition of. And the other schedule is with respect to some of the properties held by the company. I have twofold submission to this. Firstly, from the shareholders list, I had shown on the last occasion that the plaintiff's name, Suchandra Bhutoria, does not appear anywhere. It is perhaps in the name of some of the shares, is in the name of Arun Kumar Bhutoria. No application has been done under sections 58 and 59, either for transmission of the shares or for rectification of the register. No appeal preferred before the National Company Law Tribunal with respect to that. So, the first round is that Suchandra Bhutoria, as the plaintiff, cannot seek partition of the shares until and unless there is a proper transmission or rectification of the share register. Now, that is one fold. And the second thing is that with respect to the properties of these companies which I am representing, the properties of the companies, the company being a separate juristic entity, cannot the properties are held in the name of the company. It's not akin to a partnership where the partners are the owners of because partnership form itself is not a separate juristic entity. Like in case of a company. So when a company is involved, being a separate juristic entity, the company itself represents the property, owns the properties. So when the company owns the properties, it is very difficult or impossible for one to seek partition and seek piercing of the corporate veil to the effect that the properties can be partitioned. Now, these were the twofold submission which I made on the last occasion. If you lordship kindly takes the claim, I had placed these 2 schedules. Now, kindly takes. But on the last occasion, I had placed pages 33 and 33, 33A and 33B, paragraphs 40A to 40B, to show the schedules and the fact that they are seeking for partition of the shares of the company. Now, on the last occasion, I had also pointed out that in respect of a company, the procedure laid down under the Companies Act 2013 is that either the shareholders, the minority shareholders, buys out the majority shareholders or vice versa. But there is no concept of partition in a Companies Act. But first, second is that when or they can of course ask for a winding up of the company. Then in that event, the company is wound up and the assets are divided among the shareholders. They are not seeking winding up of the company, but they cannot also in a civil suit. Now, if your lordship kindly takes page 35, this is where I say that under sections 241 and 242 of the Companies Act 2013, there is the provision is with respect to operation and mismanagement.
Page 35, para 47.
Para 48.
Para 48.
There is provisions for operation and mismanagement. Now, operation and mismanagement is a specific ground or provisions are available under the Companies Act to allege or contend operation and mismanagement. When one talks about operation and mismanagement and when the remedies are available under the Companies Act itself and solely under the Companies Act, then the bar under section 430 of the Companies Act is squarely applicable, bar of civil court
So
jurisdiction.
para 48 is bar under 430.
Bar under 430. I'm reading. The previous paragraph that I had placed reliance on was twofold submission, which I had indicated that the company being a separate juristic entity, the company owns the property, it cannot be divided. And secondly, the shares that they have sought for partition of, these shares are not in the name of Shuchandra Bhutoria. It's still not in the name of Shuchandra Bhutoria, as indicated in the plain. I cannot go to any other documents apart from what is annexed to the plain. I have to only rely on the plain because this is an application for rejection of the plain. So, if I am only relying on the plain, as per their own showing, there are no shares held by Shuchandra Bhutoria of the companies I am representing. So, the plaintiff now, despite not being a shareholder of any of these companies, cannot seek for partition. If they are the owner, they can ask for partition, but only in exceptional circumstances, which is not not the subject matter in this application or in this suit. Now, kindly takes paragraph 48 once. Now, when they talk about operation and mismanagement, that squarely falls under sections 241 and 242 of the Companies Act, which I will be placing reliance on in some time after going through the allegations. If your lordship now kindly takes 48, paragraph 48, page 35. Upon inquiry, the plaintiff has come to learn that various instances of mismanagement, kindly mark this word, it proceeds on the basis that it is cases of mismanagement in the affairs of the company. And all the firms as mentioned in schedule being annexure E herein has been undertaken by the defendant number 1 without any authority after the demise of dead Arun Kumar Bhutoria in the manner as follows. Now, kindly see, he also enumerates grounds of operation and mismanagement, which is squarely, in my respectful submission, squarely barred under section.
You need not go through that in details because 48, according to you, is barred by law. These particulars which deal with mismanagement, these are barred under 438. 430. So anyway, you need not go into this.
I'll just indicate what are the operation and mismanagement grounds and how they have taken and how they fall under sections 241 and 240.
See, if they are barred under law, you did not go through this in detail. This is not a question of fact, because you see, like the question of law.
I found out what has fallen from your lordship. Kindly takes the Companies Act once. Kindly take the Companies Act. Your lordship,
Yes, section.
Section 241 first, and then after 242, what are the reliefs that can be claimed under one of the companies? Prior to that, kindly takes 58 and 59 also. Now that I am under the placing the provisions of the Companies Act, kindly takes 58 and 59. And thereafter, just to substantiate the arguments that I made on the last occasion. 58 and 59. That Shuchandra Bhutoria's name does not appear in the shareholders list given by.
Yes.
So what are the remedies were available to Shuchandra Bhutoria instead what she has? 58, if your lordship kindly sees, if a private company limited by shares refuses, whether in pursuance of any power of the company under its articles or otherwise, to register the transfer of or the transmission by operation of law of the right to any securities or interest of a member in the company, it shall within a period of 30 days from the date on which the instrument of transfer or the intimation of such transmission, as the case may be, was delivered to the company, send notice of the refusal to the transferor and the transferee, or to the person giving intimation of such transmission, as the case may be, by giving reasons for such refusal.
No, is it the case of the plaintiff that this is not done? Is it the case of the plaintiff?
No, it is not the case of the plaintiff that it is not done. The case of the plaintiff is that the defendant numbers 1, 38 and 30, 37 and 38, if I am not mistaken, the number of the
37 and 38.
Yes,
Anyways,
these
not your
defendants are ostensible owners, and along with the plaintiff.
Okay.
So, these defendants hold these shares in trust, and the ostensible owners of 1 and 2. One
section is the remedy, which
is the
granted.
remedy which was available, which is
If this is the case of the plaintiff,
absolutely.
this is the case of the plaintiff. Plaintiff should avail this remedy. But let us see what is the case of the plaintiff.
Yes.
And how it is barred.
Yes. Kindly says, without prejudice to subsection 1, the securities or other interest of any member in a public company shall be freely transferred, provided that any contract or arrangement between two or more persons in respect of transfer of securities shall be enforceable as a contract. The transferee may appeal to the tribunal. Kindly mark this one. So, 58(1) says that if there is refusal on the part of someone to register their names, or if there is a refusal of a right of transfer of Shuchandra Bhutoria, then Shuchandra Bhutoria, the plaintiff, could have appealed before the tribunal clearly. So provisions are available to the plaintiff to appeal before the tribunal, in this case the National Company Law Tribunal, in case her name is not featuring in the shareholders list, as is the case over here. Her name is not there in the shareholders list. So she could have appealed to the tribunal for this refusal of transmission.
You see, that is not the case of the plaintiff. Wherein the plaintiff has stated that these shares ought to have been transferred, they are arbitrarily not doing so. Where is the plaintiff has stated?
Very well.
If the plaintiff has not alleged that, no question of coming to that point.
Let me rephrase this proposition in this way, in which the plaintiff, what the plaintiff has tried to do. Yes. What the plaintiff has tried to do. Now, the plaintiff Shuchandra Bhutoria is not a shareholder in any of these companies. Straight away,
that is from the record, it will nowhere appear.
Straight away, no partition cannot be granted.
Yes.
I cannot today claim that I am a co-owner of Victoria Memorial if I am not the co-owner of the Victoria Memorial. This is something as absurd as this, that Shuchandra Bhutoria, not being a shareholder, is trying to claim partition of the shares of these companies. First of all, she has to assert the right. Where will she assert the right? This is the provision where I am, which is why they are placing this provision. She could have asserted her right under section 58 or under section 59. She did not do. She chose not to do so. She did not avail her right under the statute.
Unless that requirement is complied with,
no partition cannot be granted.
Yes, that is the question. If that requirement is not complied,
absolutely, I am grateful.
No question of that.
Cannot be granted.
Yes, that is
so 58 I have shown to your lordship, that is for transmission.
Yes.
No right, no remedy has been sought for. Kindly see 59. 59 is rectification of register of members. She says, this is why I was reading the grounds of operation and mismanagement.
Which paragraph he has stated regarding rectification?
Rectification she does not need to state. What she has done is very carefully, craftily drafted this plate to show that first, I am not the shareholder, but I am still asking for partition of these shares of these companies.
The question is, you see, that is, you see, if the shares are not in the name of this plaintiff, then it is incumbent to get it recorded in the name.
I am so grateful.
Telling which there is no scope for parties.
And this recording in the name of the plaintiff comes under sections 58 and 59.
Yes, this is the provision.
This is the provision. I am grateful. I am grateful. I am grateful. Now, kindly takes now straight away sections 241 and 242. This is on a different proposition altogether. 241 and 242, what I want to show to your lordship is that operation and mismanagement, as I have shown to your lordship 58 and 59, that remedies were available with the plaintiff to either rectify the register of shares or for challenging any transmission that has happened or refusal to transmit the shares in the name of Shuchandra. Neither has she applied, nor has she complained about refusal, nor has she done anything to assert any right over the shares of the company. Now, what kindly sees 241 and 242. 241 says any member of a company who complains that the affairs of the company have been or are being conducted in a manner prejudicial to public interest, or in a manner prejudicial or oppressive to him or any other member or members. Members over here being defined as one of the shareholders of the company, or in a manner prejudicial to the interest of the company, or B, the material change not being a change brought about by or in the interest of any creditors, including debenture holders or any class of shareholders of the company. Kindly mark this. Has taken place in the management or control of the company. Kindly marks this in management or control of the company. So an application by the shareholders in respect of vis-a-vis if A is against the public interest, B is prejudicial to the shareholders, or alteration in the management and control of the company, whether by an alteration in the board of directors or manager or in the ownership of the company's shares. Now, which is why I was going through the grounds of operation mismanagement in the play. This is where it will feature. That all these allegations that the plaintiff is now trying to do squarely falls under sections 241 and 242 of the Companies Act. Kindly see thereafter. or if it has no share capital in its membership or in any other manner whatsoever, and that by reason of such change it is likely that the affairs of the company will be conducted in a manner prejudicial as to interest or its members or any class of members. So, if firstly, if it is against public interest, it can file a petition under section 241, 242. If it is against the interest of its members, being the shareholders of the company, it can file a 241, 242. And the mismanagement or control, if it is with respect to alteration in the board of directors of the company, or the manager, or the ownership of the company's shares, which she is trying to say.
So paragraph 48 according to you is barred under law, under this provision.
Absolutely.
Paragraph
not
48.
under this provision. This is the provision.
Both 430 as well as 241, 242.
Read with 241, 242.
Yes.
Why I say so?
Paragraph 48 probably.
48 and the grounds, I shall go through the grounds once, I place 241 and 242. I'll show to your lordship, the grounds that they have taken in the plate is in itself, goes on to show that they squarely places their case in the plane within the realm of 241 and 242. Within the realm of 241 and 242. And if by their own showing they come within the ambit of sections 241 and 242.
So the range will speak for itself.
Yes, this is why I was going through the grounds of operation. Now, kindly allows me to complete first 241 and 242. I'll go through the grounds of operation in the plane. Now, thereafter, kindly sees subsection 3, where in the opinion of the central government there exist circumstances suggesting any person concerned in the conduct and management of
the subsection 3 of
241.
Subsection 3.
Yes, after the proviso. After the proviso.
Okay, subsection 2.
No, not 3. After the amendment. May I see the
This is 2013.
But perhaps not.
The amendment is not here.
In 2019.
Oh. Anyway, I think the latest edition of no. Okay, subsection 3. Okay, okay.
This is the new amendment.
Yes. Okay.
Wherein the opinion of the central government there exist circumstances suggesting that any person concerned in the conduct and management of the affairs of a company is or has been in connection therewith guilty of fraud, misfeasance, persistent negligence, or default in carrying out his obligations and functions under the law, or a breach of trust. Now, B, the business of a company is not or has not been conducted and managed by such persons in accordance with sound business principles or prudent commercial practices. A company is or has been conducted or managed by such person in a manner which is likely to cause or has caused serious injury or damage to the interests of the trade, industry, business to which such company pertains. The business of a company is or has been conducted and managed by such person with an intent to defraud its creditors, members, or other persons, or otherwise for a fraudulent or unlawful purpose, or in a manner prejudicial to the public interest. But these are the provisions which says that when can a shareholder file a petition with the requisite qualification, file a petition under 241 and 242 of the Companies Act. Now kindly see 242. What are the powers of the tribunal to grant the release, which they have claimed in the plaint? I shall go through page 36 and 37 of the plaint to show how they squarely fall under this. If on an application under section 241, the tribunal is of the opinion that the company's affairs have been or are being conducted in a manner prejudicial or oppressive to any member or members, or prejudicial to public interest, or in a manner prejudicial to the interest of the company, that to wind up the company, as I have told you, two remedies available. To wind up the company would unfairly prejudice such member or members, but otherwise the facts would justify the making of a winding up order on the ground that it was just and equitable that the company should be wound up. The tribunal may, with a view to bringing an end to the matters complained of, make such order as it thinks fit. Now, 2, subsection 2. Without prejudice to the generality of the powers under subsection 1, an order under that subsection may provide for, kindly sees and marks all these provisions. The regulation of conduct of affairs of the company in future. So, the first power given to the tribunal is to regulate the affairs of the company in future. So, if the plaintiff talks about the affairs of the company and the conduct of the affairs of the company, squarely falls under section 242 2b. Now, 2a, 2b. The purchase of shares or interest of any members of the company by other members thereof or by the company. So, in respect of, if they complain of purchase of shares or interest of any members of the company, if they talk about interest of any members of the company by other members thereof or by the company, then also, and if one of the shareholders is prejudiced by such act, then also it can approach the tribunal. In case of purchase of its shares by the company, as aforesaid, the consequent reduction of its share capital. So, if their share capital is reduced, then also it can, if it's prejudice, the tribunal can order. Restrictions on the transfer or allotment of the shares of the company. If they are saying that the shares have been given to some shareholders without the consent of the majority of the shareholders, or it is bereft of the opinion of the majority shareholders of the company and is against the interest of the company, then also the tribunal can intervene and can pass orders. The termination, setting aside, or modification of any agreement, however, arrived at between the company and the managing director, any other director or manager, upon such terms and conditions as it may, in the opinion of the tribunal, be just and equitable in the circumstances of the case. The termination, setting aside, or modification of any agreement between the company and any person other than those referred to in clause E, provide that no such agreement shall be terminated, set aside, modified, except with due notice after obtaining consent of the party concerned. Thereafter, by setting aside of any transfer, delivery of goods, payment, execution, or other act relating to property. Kindly mark this. Relating to property made or done by or against the company within 3 months before the date of the application. So there is a limitation period also. It's not that they can do it for n number of years. Under this section, which would, if made or done by or against an individual, be deemed to, in his insolvency to be a fraudulent practice. Removal of the managing director, manager, or any of the directors of the company. Recovery of undue gains made by any managing director, manager, or director during the period of his appointment as such, and the manner of utilization of the recovery, including transfer to investor education and protection fund or repayment to identified victims.
The manner in which the managing director or manager of the company may be appointed subsequent to an order removing the existing managing director or manager of the company made under clause 8. Appointment of such number of persons or directors as may be required by the tribunal report to the tribunal on such matters as the tribunal may decide. Imposition of cost, any other matters which the tribunal is of the opinion just and equal. Now kindly takes note page 36 of it. Kindly sees note what and how they fall under 241 and 342. I'll come back to 430 there.
Page, para 36.
Page 36.
Page 36, yes.
But what are the allegations? Meetings of the said companies. Meetings of the said companies and firms, as stated in the schedule being annexed to E hearing, is sought to have been held wrongfully and illegally without any notice to the plaintiff, despite being owner and legal heir thereof. So, first allegation A at page 36 is with regard to meetings being held without giving notice to the plaintiff, being the co-owner and legal heir thereof. So where, if I may ask myself this question, where does the plaintiff feature in? From their own showing, from their own annexure to the plaintiff's name does not feature. She is not shown as the owner.
See, whether this relief is barred under, that is but under 430.
Civil court's jurisdiction is barred under 430.
Yes.
When
So from the relief claim, the suit is barred under that section very well.
Absolutely. I'm grateful. Now kindly see. So first is, they have not been, the plaintiff's complaint is, they have not been given notice of the meetings held by the company. Why will she receive a notice? She is not even a shareholder of the company. But by her own showing. Now, second, B. Various directors and additional directors have been inducted. Kindly, for my sake, kindly, if your lordship opens 242 and relates these allegations along with the provision. I shall show it to you. 242 B 242 subsection 2.
Yes, the allegations and the 242.
Yes, if your lordship kindly sees H 242 2H, kindly reads it with B. B says various directors and or additional directors have been inducted and the shares and the share capital of the company has been increased with malafide intention to purposefully to wrongfully gain and control the companies and firms stated in the schedule being annexed E here. So it complains of share capital being increased and it complains of directors being inducted. That comes under one comes under removal of directors comes under 242 2H squarely and 242 C talks about increase in share capital by the other members and reduction of the share capital. So 242 2C and 242 2H squarely covers the relief that they have sought in B, or the allegation that they have sought in B. On numerous occasions after demise of late Arun Kumar Bhutoria, it has held out to various persons, clients and authorities that the plaintiff was no longer associated with the said firms and the companies, and that nobody should deal with the plaintiff with regard to the affairs of the companies and firms. Kindly see 242 2A in regulation 242 2A.
Wait, you have addressed on 242 and 241. Yes. Now you are reading and showing that they are connected with 242. 241.
Yes, absolutely.
Very well. You may just read the paragraphs.
Very well. The acts and omissions as stated hereinafter of the said companies and firms, the assets and properties are acquired by the plaintiff's husband with the help of the plaintiff. The defendant number 1 and 2, along with their associates, are eroding the substratum of the said firms and the companies, and also interest of the plaintiff and her children in such assets and properties and the shares of the companies and firms. So, again, pausing here for a moment, comes under 242(2), subsection 2, and the release can be granted by the NCLT or the National Company Law. Moreover, the books of accounts of the said companies, again, if they are talking about the books of accounts of the company, comes under 240. Relief can be granted by the tribunal. So any relief they are seeking, which can be granted by the tribunals, is squarely barred. Firms including statutory books, directors' minute books, shareholders' minutes books, directors' attendance register, register of members, register of investment and documents and files containing annual returns and books of accounts of the said companies and or firms are in complete possession of the defendant number 1, and the same are not kept in the office of the said firms and companies, obviously to restrict its access to the Now, next, in spite of several requests being made by the company to disclose such books of accounts and other statutory books and records of the said companies and firms, which are being wrongfully kept in the custody and control of the defendant number 1 and have been illegally removed from the office of the said companies and firms, and the said defendant number 1 has refused and neglected to disclose such books of accounts and documents to the plaintiff, to which the plaintiff, having major share in the assets and properties of the various firms and our estate, as owner and one of the legal heir of late Arun Kumar, but again complains of shareholders register not being there, books of accounts not being given to the plaintiff.
Anyway, that registration request is also not made by it.
Okay, not made and read page 13. As a result, kindly give me one. As a result of the opposite action conducts, it is clear that the said defendant number 1 is carrying on business of the said companies and firms is as mentioned in the schedule, being annexure E, illegally and wrongfully and without any authority, and without the consent of the plaintiff having 50% share in the said firms and companies, and also one of the legal heir of the properties and assets and liabilities of the said firms and estate of late Arun Kumar Bhutoria, by practicing fraud on the plaintiff and is wrongfully misappropriating the proceeds of the business. Now, there are several judgments which talks about that even fraud can be assessed and can be gone into in by way of operation mismanagement application under 241, 242 before the NCLT or before the NCLT of the business without accounting at all for all its business and profits of the plaintiff, and is thus acting in a manner detrimental to the interest of the plaintiff, so as to cause the plaintiff wrongful loss by reaping wrongful gain themselves. The defendants are utilizing the assets of the companies and or firms and or properties and or assets acquired by late Arun Kumar Bhutoria and the plaintiff, and for making private gain and or are doing business without the consent of the plaintiff and is involved in gross financial irregularities. The plaintiff, upon raising such objection regarding the functioning of the defendant number 1 with regard to the said firms and companies and or handling the assets and properties of the said firms and companies and the estate of the said late Arun Kumar Bhutoria, have threatened the plaintiff not to say anything and or interfere in the business of the said firms and companies. The defendant numbers 1 and 2 are also refusing to disclose paragraph 49. Defendant numbers 1 and 2 are also refusing to disclose any papers of the business of the plaintiff and has taken control of all the companies. So, control, management, increase of share capital, change of registered office, issue allotment of shares, removal of directors, everything complained of in these paragraphs. Upon inquiry, the plaintiff has also come to learn that the defendant number 1 himself and or through his agents and nominees and or his authorized signatories is operating the accounts of the said companies and firms as mentioned in the schedule being annexed. The plaintiff apprehends that the defendant number 1 is seeking to alienate and or usurp the funds and assets or properties of the said firms and companies mentioned in annexure E. Annexure E have showed you lordship. I feature in some of the companies which are enlisted in annexure E, and also the assets and properties of late Arun Kumar. So it talks about all the allegations with regard to operation and mismanagement, with regard to I hope
today it will be concluded because follow the recording by your lordship. And some point of time, the reading of the plate will come to an end.
But it's not reading of the plane, my lord, senior, but definitely.
No, can you conclude today? 10-15 minutes? Anyway, submit.
Very good. But may I not only do one thing, but perhaps not one more day,
4.5 months.
one more day. But I have not taken 4.5 months.
How much you can conclude, you conclude, so that
Yes, yes,
if
of course.
possible, on the next day, it will be fixed for reply and written notes on the next day.
Close it on the next day.
But next day I'll take. Next day also, but I'll take.
Very well, very good.
Yes, if the court stops, it will not come to an end.
Well, I'm senior friend, I cannot say that the court will should stop it.
Reading
No,
out
that
the
is why I am just telling you, point out the relevant portion.
Absolutely.
Instead of reading.
I have not except for pointing out the relevant portion, not even pointed out one paragraph. The plain
You see,
consists of
the
66
moment you
paragraphs.
draw the court's attention to the paragraphs of the allegations
Yes.
of mismanagement, the section will
I'm
come.
so grateful.
So instead of going into this particulars, you just
I'll just
give a
indicate
brief
the
outline.
paragraphs. I'll indicate the paragraphs. Instead of in fact going through them, I'll indicate the paragraphs.
But may I?
53 kindly takes next paragraph at page 41. The plaintiff reasonably apprehends that the properties and assets of the said late Arun Kumar Bhuturi and AK group of companies are being alienated and or transferred by the defendant number one without the consent of the plaintiff. The plaintiff is also reasonably apprehends that the defendant number one, after taking full control of the firms and the companies mentioned in the Schedule B Annexure E hearing, and by refusing the plaintiff to operate the business and or participate in the management and administration of the said firm. Kindly mark these words, management and at page 42. At page 42, fourth line from the top.
Yes.
Management and administration of the said firm.
Yes.
Of the AK group of companies and the said late Arun Kumar Bhuturi is being siphoned off to usurp the funds and assets of the said firms and companies, depriving the plaintiff and her sons of their legitimate share in the properties, assets, funds, and wealth of the said late Arun Kumar Bhuturi. Now, our kindly takes the previous page, paragraph 54A.
Yes.
But I'm not come back. If your lordship so permission.
Are you sure that you can conclude on the next day?
On the next day, I'll try my level best. Of course, but I have not taken one.
Even on the last day, he told the same thing. He can probably
And you hold me for
Same
behind the bar.
Yeah.
Bring the written notes. I'm here for you to conclude.
Yes, but I know, but I'll try to do it as soon as possible. But kindly do not give any direction, but otherwise.
No, otherwise, because you see.
No, I understand. But
instead of your reading all things, it is not required. You have to address on order 7 rule 11.
Yes, of course I'm doing it.
Because the matter is not decided on merit. Simply order 7 rule 11.
Yes, of course. Because 241, 242 is something which is
anyway, the section speaks for itself.
Absolutely.
So why you want to go to all the particulars?
Without going through the plane, I cannot show
very referring to the paragraphs is sufficient.
I do that. On the next occasion, I'll do. I'll just refer to the paragraphs and
yes.
I'm so
yes.
One in that. After he concludes, I will give a reply to the submissions opposing the application.
You give a reply as a whole.
Yes.
Learned advocates for the parties are present. Learned advocates for appearing for defendant number 4, 6, 10, 4, 5, 6, 10, 13, 24, 28, 30, 31, and 34 have made submissions but could not conclude the same. Thus, 17/7/2026 is fixed for conclusion of the submissions of the said defendants. Yes.
kindly consider 2 p.m.
The matter to appear on 17/7/2026 at 2 p.m.
For 17th, Sarkar will finish.
Yes, he has to finish it.
Yes.
I'm keeping it at 2 p.m. You please finish it.
I'm grateful to you for such a patient.
Come with the relevant points
Yes, yes, of course.
regarding order 7 rule 11.